case briefs, and so much more. LSData's got what you're looking for.
The drama unfolded between Panike and Sons Farms, Inc. and Four Rivers Packing Company, both Idaho-based agricultural enterprises, in a 2009 court case that set industry tongues wagging. At the heart of the dispute was a preseason contract for onion sales, a common occurrence in the agricultural world, but one that spiraled into a legal tug-of-war involving the stern interpretation of contracts, market prices, and the contentious concept of damages. The dispute began when Four Rivers rejected the onions on the grounds of nonconformity to the contract terms following Panike's failure to deliver onions from the designated fields. While Panike claimed there was no conclusive agreement, the Idaho Supreme Court dismissed this argument, holding the contract as valid while affirming Four Rivers' rejection of the onions. It was in the realm of damages, however, that the lower district court tripped up. Its analysis of Four Rivers' loss neglected to consider the good faith and timeliness of the buyer's actions, critical factors under Idaho's contract law. Moreover, the court's calculation ignored the market price differences between packed and unpacked onions, swinging the damages calculation off balance. After reviewing the dispute, the Idaho Supreme Court ordered a fresh calculation of damages, which amounted to $181,250. This was computed by subtracting the contract price from the market price of the 25,000 hundredweight CWT of onions involved. This decision marked the close of a bitter dispute, with neither company receiving reimbursement for attorney fees or appeal costs. The case underscored the crucial role of trade standards and good faith actions in business disputes, serving as a stern reminder to sectors across Idaho and beyond.
Case briefs and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.